Hi, thanks for attending today. I'm Bill Marple, the Director of Pro Bono and Bar Relations for Legal Aid of Northwest Texas that partners with DVAP in a joint pro bono program in Dallas County. Our Driver's License Restoration Project is a program funded by the Legal Services Corporation's Pro Bono Innovation Fund. You can help if you take some of these cases that take only 2 to 4 hours to handle. DVAP provides malpractice coverage for the cases taken through the program. Brittany Moore, our presenter today, is the attorney who runs the Driver's License Restoration Project. To say that she knows everything there is to know about restoring driver's licenses and state IDs is an understatement. She's a graduate of South Texas College of Law and worked as an Equal Justice Works Fellow at Beacon Law in Houston, doing what she does now. She joined Legal Aid of Northwest Texas in October 2019 to run our special project. She was an all-star college volleyball player and holds several all-time records for blocks. So Brittany, I'm turning the program over to you.
Hi, and I wouldn't say I know every single thing, but I know a lot when it comes to driver's license restoration. And thank you, Bill. Bill is our Director of Pro Bono Services at Legal Aid of Northwest Texas. If you don't know too much about us, we serve 114 counties. We have 27 offices in North and West Texas. So I'm going to go through kind of different barriers when it comes to driver's license and driver's license restoration, as well as kind of give you a little bit of detail of our work and how we handle these cases in our office. It is a little bit different than private style representation. This training will give you enough information for you to understand it for your own use in your own practices. But again, like I said, kind of geared also towards you volunteering with us and taking some of these cases for us. The need is huge across Texas. Thousands and thousands of Texans need this help, and it is quick and easy, about as easy as it gets when it comes to doing, volunteer cases for us and with us. So I'm just gonna jump right in. This is just kind of an agenda, what we'll talk about. We'll go through the legal authority, and we'll talk about occupational driver's license. We'll talk about suspensions, collateral consequences if your plea is entered, and again, talk about a little bit how our volunteer and coordinating works with our office and with Dallas Volunteer Attorney Program. So more than 50% of the legal needs of the homeless population relate to ID and driver's license issues. They don't have that identification, and so they're unable to not just gain employment and even access to housing, but even access to benefits. There are some shelters that won't even let people in without some sort of identification. And as you know, if you have a barrier to your license, although it won't prevent you from getting an ID, there's still that fear of arrest when you go to get it, right? And so they're kind of one and the same. We try, and then if you're gonna get identification and you are in age and capabilities to drive, the preferred method of identification would be a license, right? Because it gives them also that opportunity for employment and so on. The inability to have this identification again creates huge issues for our clients and the populations that we serve, which is that population below the federal poverty guidelines and the homeless. So this is just general kind of what we do when a case comes in for us. So client comes in, says, I've got issues with my driver's license and ID. First, at Landwit, we determine their financial eligibility because we can only help clients since it is a legal aid service and it's free. We can only help clients who fall below a certain percentage of the federal poverty guidelines. You guys may not have to take that step in your own private practice, but if you work for us, we determine that eligibility already when the applicant comes to us. We have them fill out a questionnaire so we can get as much preliminary information as possible as to what their issues are. And then an attorney takes a look at the file, completes an intake, speaks to the client, and then does a screening by way of checking their driver's license eligibility and any Omni Holds. And we'll talk about that screening here in a second, so you know where to look when a client does come and tell you that they have something wrong with their license. Here's how you can figure out what is wrong with their license and how you can help them as an attorney. If we find something wrong with their license, then we move on to drafting documents, drafting retainers, and for us, affidavit of inability to pay costs, which we couple with our motion because our motion is a request for finding of indigency. And we get all that signed, filled out. And then if you volunteer for us, we pass the case to you, right? So if you take a case from us, all of these steps are already taken before you even touch the case. And so you don't have to worry about that. But again, we'll go through how that's done. So that way, you know what to look for in your own practice as well. And what to look for, even if you did take a case from us, so you can kind of double check our screening and what we did. So here's the first website that we check. This is the driver's license eligibility page. Here is the link. It is free and public. All you need is their driver's license and ID number if they have had both in their lifetime in Texas. The reason I say both, because DPS, for whatever reason, way back when they began issuing IDs and driver's license, they did not sync those records online. Although they can see both, they're separate. They have been syncing them now, moving forward in the last couple of years, but that's also why they make you only have one. You can only have either the driver's license or the ID. You have to surrender the other once you get the other, because they are working on making sure that they're one record. But however, if a client comes in and they tell me they have an ID and they have had a driver's license before in the past, then I make sure to get both numbers, because you need to perform this check with both numbers, because you could get different information. The ID might say eligible and the driver's license might say it's ineligible. That's totally possible and does happen. So you want to get both numbers if they have had both in Texas. Otherwise, again, those are the only numbers you need. In addition to that, just their date of birth and last four of the social, not the full social, just the last four. And then you can type it in, get this search done, and it'll pull up everything you need to see about their license. It'll tell you what suspensions they have, how long that suspension is going to last, and even how to comply with that suspension or relieve themselves of that suspension, if that is in fact a possibility. So here are the enforcement actions or suspensions that I was referring to that you might see on a driver's license eligibility page. There are 4 categories. These are the 4 categories: an ALR suspension, a department suspension, a mandatory suspension, and an SR suspension. An ALR suspension is exactly what it says. It's a civil procedure for removal of driving privileges. Typically, for most of my clients, it's because they didn't want to do a breathalyzer test. That's where that ALR suspension normally kicks in. A department suspension is something administrative that DPS enforces for some sort of violation. Mandatory suspension is where it's a set 120 days or 80 days or a year suspension, right? There's a beginning and concrete end date that you can do nothing about. You just have to wait till that end date before you can get a regular valid license. And then SR suspensions are typically a result of some sort of no insurance citation or accident, right? So if they get into an accident, they'll get this SR suspension as well. This is normally, does not have an end date. It's normally a 999 date, which means forever and all time until they get the proper insurance. More enforcement actions that you'll see on a potential client's driver's license is a cancellation, denial, revocation, and prohibition. They basically all mean the same thing. It just means DPS is saying, no, I'm not giving you a license because you can't have one for one of the 4 categories listed in the previous slide. And that's essentially what all 3 of those mean. So back to those categories of suspensions. Mandatory suspensions are coupled with $100 reinstatement fee. So these reinstatement fees follow any suspension. However, even if they have multiple offenses under that suspension, the reinstatement fee will only be charged once. Meaning, here's a list of mandatory suspensions. This list has 23 things, right? So a person could have committed 5 of these offenses under mandatory suspension, but they would still only be charged that one $100 reinstatement fee for that category. These will all appear on their list of reasons why their license is ineligible. But again, that fee will only be charged once when they commit whatever offense that is that's on this list. So something to keep in mind about reinstatement fees is for each category, a client will only be charged 1 fee for that category, never more than 1 until they are relieved of it. So again, here's the list of the mandatory suspensions that a client can get: boating while intoxicated and evading arrest, driving while license invalid, unlawful use of a license, graffiti, drug offenses, DWIs. These would lead to those different mandatory suspensions. And these could range anywhere from 3 months to 2 years, depending on the offense itself, and actually how many times the offense occurred could also weigh in on the duration of that mandatory suspension. Administrative suspension. So DPS can suspend or revoke a driver's license on or after an opportunity for hearing. Again, this category of suspensions has a $125 reinstatement fee. Here to the right is a list of the different types of administrative suspensions. But again, that fee can only be charged once for this category, although they can have multiple, DPS can have multiple reasons for the suspension based on the list right here to the right. So back to the hearing. When someone does get an administrative suspension, they do have an opportunity for a hearing. The good thing is, oftentimes when a client does go to this hearing and actually is actively working on relieving themselves of that suspension. So let's say the suspension came for repeated violations, and it was four or more traffic violations is why this administrative suspension occurred through DPS. They can go to the judge at this hearing and say, I am actually right now already working on these tickets. They were all in City of Dallas and they all gave me deferred and community service. A judge more often than not will say, okay, then I will reset you a month from now or 3 months from now, see if the tickets are cleared, and then you'll never have to deal with the suspension at all, which is good for the client because then they don't get charged this reinstatement fee, for one. And then number 2, they never have to deal with the suspension at all, right? So that is a good thing for the client if they attend that hearing and attend it timely. And so that last part that I just said is also very important. Very seldom do I ever actually get a client that comes to me in time to attend this hearing. So DPS is going to send the notice of hearing for this suspension to whatever address is on their license. Of course, for our homeless clients, they're not going to get that piece of mail in time. They are transient. They're checking mail at one location once every few months. They likely missed the deadline for this hearing, and you cannot request another one. And so that's tough. And then not just for our homeless clients, a lot of our other clients move a lot because of just that lifestyle of living in poverty, you know, having to relocate constantly, stay with friends and family, get your own place, move to a cheaper place, going in and out of public housing. Their address changes, and our clients don't often update that on their actual license with their record with DPS. And so they miss these notifications, and so they don't go to the hearing. So again, not very often do I even get a chance to go to these hearings with a client or advise a client on this hearing, because they don't get the notices in time to make it to the hearing. But if they do, they can get a very positive outcome. So it is something to keep in mind if someone does come to you in time to attend a hearing like this for an administrative suspension. These are held in JP court as well. Each JP county has a specific court that they just kind of funnel these to, right? In Dallas, I believe it's, I forget, I'm blanking on her name. It's right next to Judge Jones' court. But that's where they kind of funnel all of these administrative hearings. Don't get me wrong, you can appear in front of other JPs, but a lot of them just kind of go to the same one. And they all work pretty well with clients when it comes to these suspensions, because they know how rough they are to overcome and the fee that accompanies it. Under 21 suspensions, so these can also lead to revocations and denials and other suspensions for violations for people who are under the age of 21. You can look at this list as you go back through this PowerPoint if you ever want to familiarize yourself in more detail with it. Administrative license revocation, so that's the ALR suspensions. These are typically, again, has a $125 reinstatement fee, but it's typically for when people refuse to take their breathalyzers or blood tests. Anyone under 21 with detectable amounts of alcohol, if someone does get this suspension, they will have 15 days to request a hearing on the suspension in order to relieve themselves of it. I guess that's pretty much all you really need to know about that. They have made it a smaller suspension, like smaller number of days. It used to be a year, ranging from a year to 2 years. I believe now it's about 3 months to a year. But definitely if someone can go within those 15 days to this hearing to avoid the suspension, they want to do that, again, to avoid, that $125 reinstatement fee. I think I saw something in the chat box. If anybody has questions, feel free to put them up there. I will go through them at the end of the PowerPoint. And then also just generally ask if anybody has questions. So feel free to type them up if you are worried you might forget before the end, and we'll touch on it at the end of this presentation. Denial of issuance or renewal of a driver's license. Again, DPS has the authority to deny issuance or renewal of a license for any one of the reasons over here to the right. Minor criminal mischief offenses, furnishing or purchasing alcohol to a minor, and so on. So you can look at this list a little bit more. Another reason is Omni-based holds, which we'll talk about in a second, especially if they are across state lines. You'll see that when you pull up their eligibility, that it was an out-of-state hold. Of course, we're limited in our practice to represent people in other states outside of Texas, unless you're licensed in those other states. I do give information for clients who do have those holds on how to relieve themselves of those holds, and maybe even resources on who to contact in those states respectively to figure out how to relieve themselves of those holds. But otherwise, we are kind of limited. If you're only licensed in the state of Texas as an agency, we are only licensed in the state of Texas. And so I can only kind of give information for those out-of-state holds, but they can relieve themselves of those holds, and then therefore relieving themselves of the hold in Texas and barrier to getting their license in Texas. And so that would be the biggest reason you want to at least give them some information on how to take care of it, because it will prevent them from getting a license here in Texas. Sorry, I have a 4-year-old here and he's needy.
I'm not 4, I'm 6.
Oh, I'm sorry, 5. Okay, court ordered suspensions, revocations, and cancellations. Here's the list of court orders over here to the right: delinquent child support, mental incapacity, chemical dependence, failure to renew as a sex offender are all reasons that they can have these court ordered suspensions, revocations, and cancellations. These are forever. There is no end date. They just have to take care of that requirement. And they cannot, for these specific things, get a ODL. While they're waiting to take care of it. They just have to take care of it before they can legally be driving on the road. The most common that I see is going to be the failure to renew as a sex offender. A lot of clients will say, oh, well, the court has my information. That's great. You still have to register with DPS. Or I did register with DPS when I moved here 5 years ago. You have to register yearly. I'm sure you've come across clients, if you practice criminal law, who probably try to avoid that or move to avoid that, which is the whole reason DPS places that suspension if somebody does not do that on a yearly basis. And they do have to go in person, schedule an appointment to do so, which is tough right now because their appointments are so backed up. But they do still have to do that and meet that requirement, or DPS will automatically place a hold. And that's the most common one that I see. The mental incapacity, typically, or chemical, typically what DPS is asking for is really just proof that for whatever notification they got from a doctor or from a case that said that you could not be on the road for these reasons, are now invalid, right? So if it was for mental incapacity, they're on their meds, they can drive, they are safe to be on the road and in the communities. That's what DPS wants to see, and then they'll relieve themselves of that hold. Again, there is no end date, they just have to meet the requirement. Another common one I see is delinquent child support. Unfortunately, as we all know, child support never goes away. And it is the same way with DPS. They will not relieve the hold until they see proof that at least a payment plan has been started and been paid, or the entire amount owed in arrearages has been paid. It's just like every other statute regarding child support. It doesn't even go away when you die, right? So it kind of sucks, but there are some ways and some court orders and some things that I can do sometimes to send to DPS to help relieve this hold every once in a while. But for the most part, it's going to be paying it is going to be the only way to relieve themselves of that hold. Occupational licenses and ODL. So it is a restricted license. So some of these suspensions that are mandatory, or ALR suspensions, things like that, you can sometimes get an occupational license in order to at least get the client on the road until you help take care of that hold, or they're relieved of that hold naturally, or that hold expires, or whatever the case may be. You can get an occupational, in most cases, you can get an occupational license for them to be able to legally drive to and from work, or to and from whatever that necessity is, until they relieve themselves of those suspensions in order to get a regular license. So this is, again, a restricted license, meaning that oftentimes when you petition for it, you have to specifically state what counties they'll be driving in. So if I live in Dallas County, and my client lives in Dallas County and works in Tarrant County, you want to include both those counties in your petition, right? You're requesting that the client be able to drive in both Dallas and Tarrant County. Some judges will ask for a specific time frame. My client works at 8 a.m., gets off at 5 p.m. So we want that time frame to be 7 a.m. to 6 p.m., right? And so a lot of judges, depending on why you're requesting that ODL, will request something that's specific. Some of them will just grant it based on the counties that they need and just say, okay, you're good from 5 to 10 or 5 to 12 or whatever. But some of them do get a little bit more nitpicky and specific, again, depending on what they need the occupational for. So occupational kind of speaks for itself. If they need it for work, then it'll likely be approved, right? That job falls under an essential need category occupational license. There are two categories. interlock, and essential need. Other things that could qualify for essential need other than work could be a single parent who doesn't work, but maybe has 5 kids, right? So I'll have clients who I can submit their food stamp letter as proof of their poverty and their number of children, because it lists the name of the children. So the court can see that it is a need for this person to be able to get on the road, regardless of their suspensions on their license, because they've got to drive these kids to school, they've got to take them to doctor's appointments, they've got to drive to and from the grocery store. All of those things could qualify as essential need. Caring for an elderly person that you live with, if you live with a sick parent or disabled family member, that could qualify as essential need. It's all a part of just proving up that need and why it is in fact essential. So that's an easier occupational license. It's the most common occupational license. And it is pretty straightforward. More often than not, you won't even have to go to a hearing as long as your petition is detailed as to the need and what the need is, and then you include the proof of that need. So you're working, a letter from the employer that that person works there, then the judge will likely just sign the order and send it back. So essential need is pretty straightforward. Interlock occupational license, however, is a little bit trickier. You will have to go to a hearing. That hearing will likely be in district court. That reason is because an interlock ODL is because that person was required to have an interlock because that person had a DWI or DUI. So in those situations, of course, when someone is convicted of that, they get a suspension and they're unable to drive from DPS. The only way they can drive is by way of this interlock occupational license. There's a lot of preliminary steps that I take generally if I have a client who comes in with this issue, and I know it's going to be an interlock occupational, is I check their criminal record to see how many DWIs they've had, right? You have to think of it in terms of you are asking a judge to let someone drive who has been drinking and driving, like convicted of that crime. So when a client comes in to ask you for that, you have to kind of logically think like, if I were a judge, would I put this guy back on the road? Because that's what they're gonna say. And yeah, we have some judges who are a little stricter than others. So I'm not saying you should deny a client if you don't think it's likely. I'm just saying be sensible when you take on or don't take on these cases, because if it's somebody who's had 4 DWIs, they're probably not gonna get an ODL. I don't know a judge that would say, yeah, let's put this guy back on the road. But if they've only had 1, maybe even 2, then you probably can. Another thing that I do when I have these clients is I check with if they are on probation, I will call their probationer and say, hey, have they been peeing clean? Have they been checking in? Yeah, they're a year into it. They've been doing great. I'm the one who sent them to you to get the ODL. And I'm like, awesome. Hey, when I have this hearing, do you want to say that to the judge? And that helps, right? So, and it also gets the prosecutor off my back, because could potentially be contested by the prosecutor. And so if you have that probation officer on your side, even better, because then you don't have to worry about it. And then that PO is saying, yeah, this client has been doing great and deserves to be on the road so they can get a job and work and make more money for their family, whatever the case may be. And then it'll be granted, most likely, more likely be granted. This isn't a mandatory statute. A judge can say no if they want to. So you just want to build your case as much as you can if you do come across this situation for people with DWIs. But it is totally possible. But just if you're prepared, right? Being as prepared as possible will give your client the best chance of getting that interlock ODL granted. I've even talked to court coordinators before these hearings just to see, I'll be like, hey, how many has this judge granted? And I've had some coordinators say like only 3 in the 10 years he's been on the bench, which doesn't necessarily tell me I'm not gonna petition, but it just tells me I need to make sure I have all my T's crossed and my I's dotted. SR22 insurance. So if you're going to go the ODL route with any clients and help them with that or advise them of that, They also need to know that in addition to a printout of their driving record when they petition, they also need to show proof that they have SR22 insurance. SR22 insurance is special insurance for people who should not be driving, basically. A lot of people are like, oh no, I don't have insurance because I can't have insurance because I don't have a valid driver's license or I don't have a car. That's exactly what SR22 insurance is. It's for you, for those people. And DPS will say that you need to get this insurance because you keep driving even though you're not supposed to. So you have to get this insurance. And this insurance is a requirement for an occupational license. I always tell my clients shop around to try to get a good price. Some of them can be pricey, but I've had clients tell me that they found not inexpensive, cheaper ones that they were able to afford just by way of just shopping around. So I know a lot of the smaller companies offers better prices than the larger companies like Geico or Progressive when it comes to SR22. Occupational license. So another thing to remember with occupational license for however the client gets it, whether it's essential need or ODL, they still have to send that to DPS. They need to get 2 copies. They can keep 1 copy in their car, and that will allow them to drive immediately after the judge signs that order that day. They keep it in their car, and that is valid for 45 days. They still have to send a copy to DPS with $10, because that's the fee, because they will actually send a card. DPS will send a card that is going to be their occupational license for whatever duration you petition for. So they will send that $10 for that card, the SR22, and the order to DPS. After 45 days, that court order does expire. DPS will get that back within the 45 days if you send it immediately after you get the order. I've never had a client come back and say, oh, I didn't get it back in time. No. And that's partially because I send it for them. As soon as I get that order, it's going in the mail to DPS. It takes them about 3 weeks to process. If that, it does have to get mailed to that address in Austin. They cannot take the order to an office in their local office to get it. It has to be mailed. They have to wait for that card to come back. If they owe reinstatement fees, the fees that I was talking about in earlier slides, that also has to be paid. Reinstatement fees are not like a fine or a ticket or a warrant. They don't render someone's license invalid or they can't be arrested for it because it's just a fee from DPS. However, DPS won't give you anything until you pay it. So you're applying for a license, an occupational license, whatever from DPS, and you want them to send them something, they're not going to send it to you until you pay that reinstatement fee. So if they do in fact owe those fees, that also needs to be paid either with the packet you send DPS or beforehand online, which you can do at that eligibility link. There's a place where they can actually pay online too. So they can actually pay for that whenever. They don't have to wait till their license is valid to do so. They can just get rid of it. Here is the printout of what that eligibility page looks like that will tell you what suspensions the client has. It will say that their license is eligible or not eligible. Again, you want to perform this search under their license number as well as their ID number if they have ever had both in the state of Texas. And it'll say over here to the right in this highlighted portion. Here are samples of what the suspensions will look like. So this sample has an SR suspension. So that person, DPS is requiring them to have that SR22 insurance. And as you can see, there's an end date of never, 99999, basically saying we're not going to relieve them of this hold until they send in proof that they have this insurance. Most insurance companies send it automatically anyway to DPS. They're supposed to, but I wouldn't rely on that. I would tell the client, go ahead and mail it to DPS yourself. The address is right here at the bottom to this compliance department and PO box. That's where they need to send it, and they should just kind of just do that automatically so DPS can get started on relieving the hold. That second hold category was for an accident, it looks like. And so they can apply for an occupational license. I try my best to relieve the accident hold before doing an occupational license, and that's by way of some sort of settlement. So if I can get a hold of the insurance company and arrange a payment plan through the courts or with the insurance company and send proof of that arranged payment plan to DPS, they'll relieve the hold. If it's been more than 10 years, and some certain accident holds, it's only 2 years, you can get an SR60 for a dormant judgment or a SR88. Those are other ways you can also relieve the hold without even having to go the occupational license route. Again, if you can do that, that is preferred, because with an occupational license, you can only have so many and they have an expiration date. And so if they never relieve themselves of the hold, once the occupational expires, they're back where they started. In addition to that, they have to maintain SR22 insurance. So pay for that extra special insurance for as long as they have an occupational. So if you can get them a regular license, that's preferred, because then they can just get regular insurance versus getting SR22 and having to maintain SR22. So something to keep in mind when you're looking at these and how you want to help the client relieve themselves of the hold. These options that I was referring to of how they can relieve the holds, they're going to be here to the right under compliance instructions. I've had people say, well, why can't the client just look this up and follow that and do that themselves? You're right. That is totally possible. However, you know as well as I do that a client is going to read this and see SR22 insurance or contact court for civil judgment or occupational license, and it is Latin to them. And they're just, I don't know, I don't understand what it said. And so they're in the same position, right? They still have no idea what to do. We as attorneys, our law cases all had Latin in it. And so we're in a better position to be able to help our clients gather these documents or get this occupational license or get these things to then send to DPS, especially when it's an accident hold, because it is involving some sort of court disposition. So they will very likely need to either contact the court or file some sort of motion with the court to get something done. And that's where we can step in and help them do it. Easy for us, not easy for them. Here is if you keep scrolling down, when you pull up someone's eligibility on that page, you'll see what reinstatement fees they owe here in this bottom box in the bottom right corner. As you can see, there's only one fee for each category. This particular client had one from all 3 categories, but that will be the most a client will ever have to pay in reinstatement fees, because again, they will only charge one category, but they could have all 3. I mean, it just depends on what their license is suspended for. And this will also tell you here in the top right that number 1, don't worry about number 2, that doesn't exist anymore. But number 1 will tell you that you also need to check the other link that I discussed in the first slide, the Omni-based system for outstanding warrants and citations that they need to pay. And that needs to be taken care of as well in order for a person to really have a valid license. That number 2 is surcharges. That does not exist anymore, at least when it comes to DPS. Surcharge program was just another set of fines and fees. So a client could have to pay the court, and then could have to pay the court surcharges, and then would have to pay DPS surcharges. Now, the DPS surcharge program does not exist. It is gone. Thank you, Jesus. But you might have clients who confuse that with a reinstatement fee. They are not the same. Or they may not even realize that their surcharges are gone and they still think their license is invalid, but it's not, because the surcharge program ended in September of 2019. And so they have a valid license and they can just go get it. So it's something to keep in mind. If somebody asks you or a client asks you about surcharges, they do not exist anymore when it comes to DPS. They exist in the courts when it comes to DWIs, but not that program in DPS, which was actually worse because it would rack up. It wasn't just a one-time fee. It just kept adding every some odd months. Here are some more examples of suspensions. Trying to make sure I keep a little bit of time for questions. Is medical advisory board. Again, if someone has that sort of revoked license, maybe it's because they're colorblind or something of that nature. The only thing that will relieve them of that hold is sending some sort of, there's a whole list on the DPS website of how they can relieve themselves of that hold. The biggest thing is getting that doctor's kind of letter signed saying that they can get back on the road, essentially. Canceled interlock requirement, just another example of another cancellation on a license. Again, it's for Infinity. And really, this is actually easier than it sounds. A lot of clients, after having the interlock requirement placed on them for some sort of criminal case, either the court didn't send the order that they were released from probation, or the client or attorney didn't send the order to DPS. And therefore, DPS is just like, well, the case might be done, but we don't know if they still have to have it interlocked. So just tell us if they don't, and we'll release that hold. And that's all it is. So normally I can just call a clerk and have them sign a document saying that they've been released of that requirement for an interlock, send that to DPS, and they'll take care of that hold. So that's a pretty easy cancellation. Again, a couple more examples. I'm not gonna spend too much time on it, but one of the more common ones that I see is that drug education program. Keep in mind, they can do this at any certified program. They could go do it through their Salvation Army. If they're homeless, they could go do it through their regular drug counseling. If they're already on probation for some other criminal charge, any certified program can count for these 15 hours, and they just have to send at least proof of 15 hours to DPS, and DPS will approve it. There's no like special sanctioned, people say they are, but any program can count. I've sent jail programs for clients before. As long as their counselor signs off on the hours and has a log that shows proof of at least 15 hours done, I've sent that to DPS and they've relieved the hold. So just something to keep in mind when you see that drug education program suspension. This is just a slide talking about the surcharges that I've already discussed with you. Doesn't exist anymore. They've restructured certain surcharges. And again, that's just specifically regarding DWIs. Here's what it was to the left where it says 2003 and 2019 after the surcharge program was gone. Here's how they kind of restructured it. It's a lot more money, but again, for our clients or any of you who have clients who might qualify, if they are indigent, that fine can still be waived for the inability to pay. So it is higher, but for our clients, that can still be waived. Failure to pay and the Omni-based system. So this is the other check that I was referring to. I'm just gonna move on since we're kind of getting close on time. This is what that site looks like. Here's the link over here to the left. All you need is their driver's license and date of birth. It is unlikely that you'll be able to pull anything on an ID number. You can try, but if they've never had a license number, you probably won't be able to pull anything in the Omni-based system, which is okay, because even if you look at the Omni-based system, you should still be checking each jurisdiction that the client says they have pending matters in individually, right? So what I'm saying is if they say they have City of Dallas tickets, you should still go online to City of Dallas Municipal Court and run their online search with your client's name and date of birth to determine what citations and warrants they have in that court. With Arlington, with any other court, you still want to check that jurisdiction individually, even after you check this website. This website, only 50% of the courts report to it, and even the ones that do, like City of Dallas, which does report to the Omni-based system, it won't be updated. So you'll see one warrant on this website for City of Dallas, and then you'll go to the City of Dallas website and see 7. And that's totally possible. This website is still helpful though, because it'll tell you what DPS is actually placing a hold on them for. And it's the ones on this Omni-based system. I've had people ask, well, if they have warrants that are not in the Omni-based system, will that prevent them from getting a license? Yes. And just think of it as if they can go to jail for it, they can't get a license. And so if they have warrants that don't come up on the Omni-based system, yeah, the DPS still doesn't give them a license, and they still know that they have those warrants out there. This Omni-based system, though, like I said, is helpful because it will tell you the name of the court, the jurisdiction, the address, and the phone number to contact for them. And okay. And so it'll tell you the jurisdiction, the information, and everything you need, the citation number, offense date, what the citation was for most of the time, as well as the total fine cost. And that is helpful for you to, obviously for the client to know in private rep. And then also for our purposes, we want to know how much we relieve the client of paying when we are requesting that finding of indigency in lieu of paying the fines and fees. So that's just a sample of what that page looks like. I will email, or Maricela has this PowerPoint, and if any of you want it after this presentation, she can email that to you. Resolving Omni Holds, these are the common ways to do that: paying for those tickets, doing a driver safety course or deferred adjudication in those courts. If you enter on record, the court may require you to pay a bond for that client, or doing a time serve request if you know your client has served time. I do my time serve request, really, it just has to be within that jurisdiction. So if they serve state jail time, they can use it in any court in the state of Texas. If they have served Dallas County time, they can use it for any jail or any citation in Dallas County. And the date has to be, of incarceration has to be after the date they received the citation. Okay, so that is how you can get time served. It is now $200 a day due to a new law for clients. So something to keep in mind when you are, if a client does request time served. For our purposes, for our clients in representation, we don't want our clients to pay anything. So we will request time served if they've served time. We will request a deferred if a deferred is an option, but instead of paying the deferred fine or paying the fine at all, we will be requesting that the court waive that fine and fee for because our client is indigent, or grant community service in lieu of the fine and fee because of our client is indigent. And I will tell you a little bit more of why and how we are able to do that. Article 45 of the Criminal Code allows the court to do that. In fact, it even allows them to waive it, or not waive it, dismiss it altogether if they find our client is indigent and it is in the best interest of justice. It also allows them to waive the Omni fee, which is that $30 fee, and any other court costs that are associated with the citation itself. So when we represent our clients who obviously couldn't afford the ticket, for our clients, a $300 ticket, which for us, we would just pay. But for our clients, that is their portion of rent after housing pays their subsidy or their voucher. That is their electric bill. That is their food and clothes for their kids for that month, or maybe even that year. Or if my client is homeless, I mean, they don't even have bills to pay. And they certainly don't have the money to pay it if they did. And so our clients, it becomes this $300 ticket that then the next time if they get pulled over again is a $600 ticket for the no valid license. And then if they still don't pay it, those double because they become warrants for failure to appears. And then now it's what we're at $2,000. They couldn't pay the $300. What's going to happen with that $2,000, right? So it sits there for years and years, and maybe even accumulates more for years and years. I've had 60-year-old clients who have not had a valid license since they were 30 because they just couldn't, never. And it wasn't like they had racked up all these traffic offenses over the years, right? It's like normal. They might have had one every 2 years or one every 3 years, a speeding ticket, like any normal person, but they just they couldn't pay it because it became a choice between their livelihood and paying this fine. And so we're advocating for the client and telling the court, hey, let's come up with something else that they can actually do, that they can actually complete, so that our client can take care of this citation for themselves and for your court. So you can get it off your record, because you're spending more money hiring people to try to call them to get this money that you're never going to get. So it's kind of, it helps everybody. Let's just get rid of it, take care of it. If you're not comfortable with dismissing, if you're not comfortable with waiving, then let's give them community service. And here's the relevant authority for all of those requests. Here is a sample of my motion and template. If you take a case with us at Legal Aid, we will give this to you. You are not working from scratch. I try to make this as easy as possible. So I will give you my template. You just edit accordingly. The affidavit of inability to pay costs, as I said, this will be included because we already do it at our intake for you and for the client. So that way you can have it ready to go in the motion already signed by the client. This affidavit not only has all of their income and expenses, but it also has some persuasive language of where they live. If they're living in a shelter, a transitional home, if they are homeless, if they are couch surfing. And it also includes a list of their dependents in their household who relies on them financially, as well as a plea of no contest signed by the client if the court is requiring that in order to find them indigent. All that will already be completed. We give you the legal aid certificate to just sign, just saying that this client does qualify for legal aid and is being represented by legal aid by way of pro bono counsel. All those things in support of that request for finding of indigency. Here is an example of what time served evidence will look like. So if I am requesting time served, I try to get some sort of proof of incarceration, which will be the facility they were at, the date they went in, and the date they went out. Oftentimes, a lot of these jails don't have some sort of way to do that online. And so you just have to kind of go up there and ask them for a letter because they have the record and they just put it in a letter and give you a copy of that on their letterhead. And here's the proposed order. I said, again, try to make these cases as easy as possible. If I don't have to go to a hearing, we all win. And so I include a proposed order, all of the evidence of the client's indigency, like I said, the plea, if the court needs a plea, so that way they can just sign this order and send it back to you or me, and then we can close the case. The client citations are cleared and they can finally go get a valid license. If community service is ordered, it's ordered on a scale of $12.50 per hour. So if the citation's $1,000, divide that by 1250, that's how many hours the court cannot go above. They can always order less. So in City of Dallas, Judge Robinson is really great about if he's giving community service to my clients, it's like 10 hours because he's trying to be realistic. He wants them to get it done and he wants them to clear their record. And so a judge can absolutely give less than that scale of 1250, but they cannot give more. And things that can qualify for community service. If you have a client who's already in a job skills program, a GED program, drug and alcohol rehab, you can ask a judge to count that as their community service. I've even counted like college courses. I've told a judge, hey, my client's doing classes at Northlake College right now. Can they count that time in class as community service? And judges have approved that before. So any sort of, basically the client trying to better themselves, if you can make that argument in front of the judge, they might let you count that as community service, which is good. I mean, I think that's a good motivation for clients to try to continue to move forward with their lives. It's the whole premise of the statutes and legislation regarding this finding of indigency is helping them move forward with their lives. This was just talking more about the credit for community service. You can ask for extensions if a client can't make the deadline. If a client works full-time, is the sole breadwinner of their household, but have a household of 7, I would definitely ask for more time. If a client is disabled and you know that when you file the motion, I send proof of that disability by way of either a doctor's note or their disability benefits, sending that to the court, I have 100% had judges say, yeah, I mean, they're disabled, they can't do community service, so I'll just waive the fines and fees. They may take the conviction, but they'll still waive the fine and fee. Collateral consequences. So most of you already know what happens when if somebody does have to enter a plea of no contest, even for our cases, even if it's for finding of indigency. So for my clients, the conviction isn't as bad as the fine, right? Like if their ticket was 6 years old, they would have already served the suspension for their ticket anyways, if they had the money to pay it back then, but they didn't, and they still don't and never will. Right? So their bigger issue is the fine itself, not necessarily the conviction. So however we dispose of the fine is still a positive outcome for our clients. Don't get me wrong, I have clients who prefer not to. And so we do find ways around it. And like I said, we are advocating always for a dismissal if a dismissal is possible. So if the ticket's 10 years old, things like that, of course, we're going to try to get a dismissal. The interesting thing about requesting a finding of indigency is a lot of my cases are actually post-plea, right? They're not in pre-trial phase, so I might not be able to get a dismissal. Or they might have already entered a plea, but I'm still filing my motion because I'm not contesting whether or not they're guilty. What I'm here to argue in front of the court is that they are indigent and they cannot pay this fine and fee. So help me come up with another option. And so again, if you want to go through this list later, you absolutely can when you get these slides. I encourage you guys to help with these cases. Take these cases in your private practice or take these cases from Landwit because it is easy work. Like I said, I've created a system to where all you do is edit that template, file it, and wait for the court to tell you what they're doing with the case. And they will grant community service at least, if not dismiss or waive. And that's what we want, right? We want this disposition for our clients. And it is a huge impact, being able to pick up the phone and let a client know that, hey, Miss Doe, I know it's been 10 years since you've had a license, but you can finally go get it. They literally jump while they're on the phone. This simple, basic thing, which kept them from so many things. And like I said, makes such this big impact, but it's such this simple, easy, quick work that you can do and help us do for these clients in this population. This is more code and changes to the law just for you to see how the legislation has improved to actually pressure the courts to dispose of these Class C misdemeanors and fines and fees, especially for the indigent population, and why they should do it. So there's a lot of code that's just developed over the last 5 or 6 years, just telling courts that you have to do it and you have to do it reasonably, right? If they give community service, but it'll cause an undue hardship, they need to waive. They just waive those fines and fees so the client can move on with their life and take care of this ticket. And so you can look in that in more detail. If you take a case from us, you're covered by our malpractice insurance. Each case will not take you more than 2 to 5 hours. Training's done right now in a lunch and learn, an hour. And we mentor you, I mentor you from the beginning to end of the case. So you're never gonna fly by yourself. I'm always here for you to touch base or ask questions if you take one of these cases from us. The logistics, as I said, we get most of the documents done and everything screened before we give you the case. We ask that you screen it again once you get it because something may have changed since then or circumstances may have changed. And it's totally possible by the time you get the case. But like I said, for the most part, we've already done everything for you. And so it's ready to go. You have access to all of our CLEs and anything you need. And here is my contact if you need it. I'm gonna leave that up and pull up questions. Does a suspension based on child support fall into any of these categories? Yes, it does fall into the category. They will get a license suspension. And like I said, when it comes to unpaid child support, the best they can do is start a payment plan and show proof of that, a payment plan through the actual registry, right, through the Attorney General, and then show proof of that to DPS, and they will relieve the hold, at least for a while until they're prompted that it hasn't been paid. So the client does have to keep up with the payments as well, or pay it all together. But that's really the best way. Maricela has included information about getting the CLE credit for the course. The course number is in the chat, and she said she would mail the slides to everyone. I'm going through a couple more questions. Yes, if you request it before the 40 days, you can still get that ALR suspension. But again, most clients miss that deadline. And that's why those hearings become difficult. And I mean, they miss it. Like they got this letter a year ago because they simply didn't update their address with DPS. And it's not that we can't deal with the suspension. We can still deal with the suspension, We just can't have that hearing to avoid the suspension because the suspension's already on their license at this point. So now we're dealing with how to relieve them of that suspension. Can someone get an occupational license if there are outstanding citations? I take care of the citations first. If they have one, a judge will probably still grant it. But if they have more than that, then no. And I only say one because the judge will say, okay, you need to take care of this soon because DPS may not, if it's a warrant, DPS won't send them the ODL. So it's not going to matter whether or not the judge grants it. DPS still has the final say as to whether or not they're going to send them this physical card. And so if they've got a ton of warrants and Omni Holds out there, DPS isn't going to send it. And so we kind of defeated the purpose of even petitioning. So I recommend clearing those citations or as many of them as possible before petitioning for an occupational license. I'm not saying it's impossible. You can get it, but again, DPS has that final say and you don't want to get pushed back or, after that 45 days when that court order expires, have to then go back and file for another one because the tickets weren't cleared in time. Why is paying child support considered so difficult? I don't know, it just is. Because it's not just dealing with DPS directly, it's dealing with the Attorney General's office who, keep that record in addition to dealing with DPS. So it's very complicated to get a hold of anybody in the Attorney General's office regarding something outside of ongoing family law cases, right? You're trying to get information about someone's arrearages that's already been determined that they needed to pay and they haven't paid for however many years. And you're trying to ask the AG's office to help you figure out how to clear that hold with DPS. It's not high on their priority list. But you can file motions, you can talk to the AG's office. Like I said, come up with some sort of payment arrangement for the client in order to relieve that hold. But again, it's just that they are more difficult cases if someone has that situation. For an interlock ODL, is it primarily the attorney making a short appeal? Does the client typically testify? The client does need to come. The judge will ask them, probably want to ask them a few questions just to kind of test their veracity, I think. I've been in situations where the client just sits in the background. They still attended the hearing, but I was able to make all of the arguments for them for the court. But every once in a while, especially if it's a judge who doesn't like granting interlock ODLs, they're gonna wanna, grill the client a little bit and just say, so you're working at IHOP now. How long you been working there? How have you been getting there if you don't have a valid license? That actually happened to me. And my client was like, I Uber. I spend hundreds of dollars a week on Uber trying to get to and from work. So can you please give me this occupational? And he did. And so yes, the client should be at the hearing when that hearing is scheduled, but they may not necessarily have to speak to the judge. That's the judge's call, really. Let me see. Do you appeal orders of suspension? No, because it's administrative. And like I said, once the suspension's there, it's there. You can, I guess, if you wanted to, but it's not gonna reverse anything, right? Because DPS standard is not the same as like a criminal standard. They don't have to have a hearing, right? If they got a police report for an ALR suspension that says they failed to blow the breathalyzer, then they failed to blow the breathalyzer, and there's no requirement for DPS to then have a hearing for the client to, for a prosecutor or police officer to prove whether or not the person actually did fail to blow the breathalyzer. It's a different standard because they're an agency and not, like a criminal court process. It's not a criminal charge per se. And suspensions do sometimes result from criminal charges. But again, that's a court sent something to them. They didn't send anything to the court saying suspend their license. The court told them to suspend their license. And so that's the other reason why you wouldn't appeal a decision unless you had a hearing in JP court for a suspension and they made a decision that you didn't agree with, that you can appeal. But if you didn't have a hearing and decision was already made, suspension's already there, there's really nothing that you can do at that point. Does anyone have any other questions? I'm not seeing anything else. Thank you for attending this. If you want to take any of these cases for us and help us meet this need and bridge the gap, contact Dallas Volunteer Attorneys. We have plenty of them to go around. And Maricela, you can close. Thank you again.
Thank you.